Good afternoon, Madam Deputy Registrar. Would you please call the matter? Thank you.
Good afternoon, President. Thank you. Caribbean Court of Justice, on appeal from the Eastern Caribbean Supreme Court, St. Lucia, delivery of reserved judgment in CCJ Appeal LCCV number 2 of 2025 between Allen Chastanet and the Comptroller of Customs and Paul Noel. The members of this afternoon's panel are Mr. Justice Anderson, President, and Presiding Judge.
Good afternoon, everyone.
Madam Justice Raj North Lee.
Good afternoon, everyone.
Mr. Justice Barrow.
Good afternoon.
Madam Justice Ononiwu.
Good afternoon, everyone.
And Mr. Justice Ebo Osuji.
Good afternoon.
May we have the appearances, please? Thank you.
Good afternoon, everyone. Should it please this court, Mr. President, Your Honors, Tanya Alexis Francis, holding papers for Mr. Garth Patterson, Senior Counsel, and we appear on behalf of the appellant, Mr. Allen Chastanet, in this matter.
Thank you.
Good afternoon, everyone. May it please the court, Mr. President, and Your Honors. My name is George K. Charlemagne, and I'm led by my learned senior, Mr. Anthony Estefan, SC, and we appear on behalf of the respondents in this appeal.
Thank you, sir. Well, we have arrived at a decision in this matter. It is a unanimous decision by the court. There are two judgments written, and the lead judgment was written by our brother, Mr. Justice Chile Ibu Osuji. And I will now ask the judge to deliver the judgment of the court. Judge?
Thank you very much, Mr. President. This is a summary of the judgment we delivered today in the case of Allen Chastanet. I'm the Comptroller of Customs of St. Lucia and Paul Noel. It is important to stress, as always, that a summary of a court's judgment is just that, a summary. It is not the text of the judgment itself, let alone an authoritative text of it, and may not be quoted or cited as such. It only provides members of the public with general information in the broadest sense. Anyone needing to cite or refer to the judgment must use the actual judgment of the court. This appeal arose from the withdrawal or discontinuance of criminal proceedings instituted in 2020 by the Comptroller of Customs against Dr. Ernest Hilaire for infractions under Section 102, Paragraph 3 of the Customs Control and Management Act of St. Lucia. The charges concerned Dr. Hilaire's alleged failure to produce a commercial invoice for a vehicle imported into St. Lucia following his tenure as High Commissioner in London. After mediation and a change in government, the new Comptroller of Customs sought to withdraw the prosecution, and the presiding magistrate granted leave for the withdrawal. Mr. Allen Chastanet sought judicial review of the Comptroller's, quote, decision, unquote, to withdraw the case, contending that by January 2021, the Director of Public Prosecutions had taken over the prosecution, thereby rendering ultra-virus the Comptroller's withdrawal of the case. The High Court and the Court of Appeal dismissed Mr. Chastanet's application for leave to commence judicial review. The Caribbean Court of Justice affirms. We find that the evidence did not establish that the DPP had taken over the prosecution. The mere forwarding of the case file to the DPP and the subsequent participation of counsel from the DPP's office in the proceedings were insufficient to establish that the DPP had taken over the prosecution. We note that the DPP himself had never claimed to have taken over the matter. We further hold that pursuant to Section 73, subsection 4 of the Constitution, only the DPP has exclusive authority to withdraw or discontinue criminal proceedings on his own. But where another authority institutes proceedings, those may be withdrawn with the leave of the court. Accordingly, once the magistrate granted leave to withdraw, the Comptroller's bureaucratic decision to withdraw the prosecution merged into the magistrate's judicial decision. And according to the doctrine of merger, the only decision that is open to challenge is the magistrate's decision, not the Comptroller's antecedent step. Since no challenge was brought against the magistrate's decision, judicial review of the Comptroller's decision was legally misconceived. Further to the disposition of the appeal on the merits, it was considered important to underscore the need for clarity when the DPP assumes control of a prosecution. Recommendations in that regard include formal written communication, public notice, and reflection of the change in the style of cause. In a concurring opinion, the Honorable Mr. Justice Barrow stresses the illogicality of the reliefs sought. The appellant's case, he observes, rests on the premise that the DPP had taken over the prosecution, yet the appellant sought orders to quash the Comptroller's decision and to compel the Comptroller to reinstate the charges. If the Comptroller lacked authority to withdraw, he equally lacked authority to reinstate. Mr. Justice Barrow cautioned against unnecessary consumption of judicial resources. For foregoing reasons, the appeal is dismissed with no order as to costs. Thank you.
Thank you, Judge. Thank you very much indeed. Anything from the parties, counsel?
Not from us, Mr. President.
Thank you, sir.
Not from us, Mr. President. Thank you.
Thank you, ma'am. Very well. Madam Deputy Registrar, would you please bring the proceedings to a close?
Thank you, Mr. Justice Anderson, President. Thank you, Madam Justice Roch-Notley. Thank you, Mr. Justice Barrow. Thank you, Madam Justice Onanu, and thank you, Mr. Justice Ebo-Suji. Thank you, Counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you.
Thank you very much.
Thank you, everyone.
Thank you.
Thank you.